Good afternoon, everybody. Thank you for taking the time to attend our webinar today. It is a snowy day here in central Iowa. We woke up to just a little bit of a dusting this morning, but it is December and it's close to Christmas, so what else should we expect? Our topic today is estate planning, and based off of our last webinar survey that we did, this was the by far and away the most requested topic that we present on today. I'm happy to share that we have clients and guests joining us from 6 different states across the United States today. So thank you all for taking the time today. Just a couple of housekeeping items before we get started today. Today's webinar will be recorded and later posted to our website. That way, if you want to share it with family and friends, you can do so. Additionally, later next week, you will receive a follow-up email with a couple of resources from today's call. Lastly, at the conclusion of today's webinar, Zoom will prompt you to take a short 5-question survey. We would encourage you to take this survey. That way we can keep tailoring these webinars to the content that you want to see. If you've not had the chance to meet me yet or talk to me over the phone, my name's Colin Miller, and I'm a certified financial planner, as well as the Director of Planning here at Harvest Point Wealth Management. One of our core values here at Harvest Point is faith-filled generosity. Therefore, on behalf of all of our attendees today, we will be making a donation to Kingdom Living, which is a Des Moines area nonprofit that provides sober housing and resources for those with addiction here in the Des Moines metro area. To kick off today's call, I'm going to share a couple of quick office updates regarding our team and the office. Then I will turn it over to Tim, and he will give you a brief update on the market. Then we will have Noah, our guest presenter, who will give us a little bit of an insight to estate planning. At the conclusion of today's call, we will have a brief Q&A session. So as you have questions about topics that are being discussed, whether it's the market or estate planning, please send those to our info inbox, which is info@harvestpointwm.com. And it should be popping up on your slide here. Yep, right there for you. We can't utilize the chat feature as well as the polls or the question and answer portion of Zoom due to compliance reasons. Great, now for a couple of office updates. If you haven't gotten the chance to meet Lauren or Jacob yet, those are 2 new team members that we have welcomed this year so far. Lauren joined us back in June after graduating from the University of Iowa. She is our marketing and client care specialist, and she helps with a lot of different things around the office, including webinars like the one you're seeing today. Jacob joined us just a couple of months ago after a short stint in the recruiting area for financial services industry, and he recently obtained his licenses and is now a financial advisor. If you can't ever get a hold of Tim or I and you need immediate assistance with a trade or have a question about a statement, feel free to ask for Jacob. He would be a great resource. Finally, if you haven't heard already, Kathy's retiring after 39 years in the industry. She's looking forward to retirement, and we all know she's looking forward to spending time with her 8, but soon to be 9 grandkids. For those of you who may not know much about Harvest Point, we exist to faithfully guide and equip our clients to wisely steward the wealth that has been entrusted to them. We offer financial planning services that are personalized, comprehensive, and faith-driven. We are proud to share that we have a 99% annual client retention rate, as well as over 85 years of combined experience in the industry. Finally, some may not know this, but we are truly family owned and operated, and we take pride in that. Next is just a brief overview of our team, because it's always nice to put a face to the name of the person that you're either emailing with or talking on the phone. For example, tax time's coming up. So maybe you have a question about a tax statement or making sure you have all your tax forms. Cameron Jensen down in the bottom right corner there would be a good person to contact. Additionally, I wanted to shout out to Cameron and Laura today because they are celebrating their 2-year anniversary tomorrow of joining Harvest Point. It's been a quick 2 years, as both of them will tell you firsthandedly, but we can't imagine what our team would be like without either of the help. So thank you to both Cameron and Laura Nilas. Finally, if you're not already a client and you want to know more about becoming a client of Harvest Point, please scan the QR code on the left. This will take you to our Become a Client website section where you can input some general information, and then Angela Gibbons, our Director of First Impressions, will reach out to you to get a meeting scheduled. If you are a client and you would like to share your thoughts about working with Harvest Point and your advisor here, please scan the QR code on the right, and that will take you to our Google reviews page. If you'd prefer to leave a private review not published on Google, you can always email those to the info inbox or to Angela. Angela's email is angela@harvestpointwm.com. Now, I'm happy to introduce our founding partner, Tim McLaughlin, who will provide everyone with a brief market update. Tim?
Good morning, and thank you, Colin. I appreciate that, and what a wonderful team update. It's evident that we have a lot to be thankful for at Harvest Point Wealth Management, and that is directly owing to the fact that we have so many great clients, just like all of you on the call today. So thank you so much for a wonderful 2024. It has been a privilege to work for you. I've gotten a couple comments today on my jacket, and you will note if you have color screens that you're tuning in on today. I think all screens are color now. I don't know that we have any more black and white screens, but that my jacket is red. So my 4-year-old, who's going on 12, comes in the morning and helps me select what I'm going to wear. And so this is what we settled on. She thought that because we were getting close to Christmas, red would be the color to go with. Now, I, on the other hand, had proposed that I wear my Clark Griswold Blackhawks jersey from Christmas Vacation. So if you're familiar with that movie, Clark Griswold can be seen wearing this jersey during the movie. So that got ex-nayed. The 4-year-old thought that might not be a good thing to wear to a business meeting. So we went with the red jacket. So like Colin said, yes, it's snowing here. So what better time to talk about the thrilling topic of estate planning. And, that's one of the things I think probably all of our clients can attest to, the fact that we have been, to one degree or another, bothering you about estate planning year in and year out. And many of you, to your credit, have made great progress on putting your documents together, or at the very least starting to put thought into it. And in fairness to you, we know it takes time and effort to think through. This is not a decision, estate planning decisions that can be made on the fly or in a moment's notice. So really, based on a lot of the feedback, like Colin said, that we have received from you in our individual meetings and also the polls that surveys that we try to do, this is a topic that is top of mind. And so we are going to dive into that. We have an expert on the call here. We just thought before we did so, I would provide just a little bit of a market update, given that we're now on the other side of the presidential election, and we have a little bit more clarity as it pertains to what Congress will look like. And so we will do that right now. Before I mention those particular pieces of information, of course, as you all know, everyone hopefully who is a client knows this. Our guests on the call might not know this. However, that at Harvest Point, the way we think through things is that the client, you are the most important person in our company. So that is kind of the running theme throughout our business. It always has been, dating all the way back to when Kathy began in the industry. And by God's grace, it always will be going forward. So we always like to communicate that. And it's a great tie-in, really, because we can help you plan your investments. We can help you hopefully grow those over time. But if we don't have a proper estate plan in place, that can create a lot of headaches for your survivors at the time you pass away, or even while you are living in certain circumstances. So that's another reason, as we try to put you first in our business, we always try to think about all the different possible scenarios that could come up. And of course, estate planning is a very important one. As it pertains to the financial markets, as I mentioned, we are now on the other side of the presidential election. And thankfully, no more political ads. That is wonderful. We don't need to hear or see any more of those for quite some time. One thing that we found interesting is if you go back over the past 10 election cycles, so dating all the way back to 1984, in the year that follows those elections, 9 out of the 10 years have been positive. There's only been 1 year that had been a negative year in the year following the election, and that was the year 2000, and it was a notable down year. But 9 out of 10 is pretty compelling data. In fact, even if we included that down year, Over the past 10 years, the average return in the year that follows the election is over 15%. Now that's on the S&P 500, and the S&P 500 is a broad representation of the equity or stock market. So it would be a phrase we oftentimes use would be an aggressive investor, someone who is only invested in equities. So to the extent that you have more of a moderate or balanced approach, then we would kind of modify those figures accordingly if we were to try to apply it to your portfolio. But nevertheless, it tells us that generally speaking, or in summary, stocks have tended to do well following election cycles. And so that's encouraging for us as we look ahead to 2025. And you'll be hearing, of course, from us with a lot more data on what 2025 looks like and what we would expect both in the financial markets and also in the economy. Another interesting thing to note is we are now over 2 years into the bull market that has been running since October of 2022. And you might be inclined to think, well, that means since we're 2 years in, that we're probably done with this cycle and we're going to have maybe the start of a bear market. If you go back to 1950, the average bull market has actually lasted 5.5 years. Which is to say, if that were to be the case during this particular bull market, then we have another, call it 2.5 years to go in this current bull cycle. I don't necessarily know that we'll make it that far because there are some headwinds as we look out multiple years down the road. But certainly, if you pair this information with the information that would show us what happens following elections, it makes us cautiously optimistic about 2025. Obviously, over the next 5, 10, 15, 20 years, we would say that we are optimistic in general about the American economy, about the consumer, about the financial markets. But if we were to kind of narrow the window to more near term, still, I think we have that optimism, and in large part due to some of the data like this that we are currently seeing. And then the final data point that I wanted to show, maybe on the contrary, or a differing school of thought, would be if you go all the way back to 1980, like this chart does, you will see both positive years and negative years. So this chart shows the calendar year return on the S&P 500 in gray. So there's both positive gray bars and negative gray bars. Obviously, at a moment's glance, you can see that there are far more positive bars than negative bars, just to make that observation first and foremost. But the other thing the chart shows is red dots and red numbers. Those red dots and red numbers stand for intra-year declines. In other words, during each calendar year, how much has the S&P 500 gone down at the most throughout the course of the year? Interestingly, again, you can see that on average, if you ran the math, it drops about 14% each year. Well, that has not been the case this year. We have only been down 8% at the worst on the S&P 500 year to date. And that is something that would cause us to pause, that probably, in all likelihood, at some point in time in the next 3-6 months, we are due for more of what we would call a correction. So not necessarily a bear market, a sustained down market, but more of a 10 to 14, as this chart says, percent decline in the market just throughout the year. That's normal. That happens once every couple of years. We would expect it to happen. It just hasn't happened in a little while. So that would be another thing that we're watching right now, and another data point to consider as we look at the near-term market conditions. So hopefully that information gives you a little bit of a better idea of where we are at the end of 2024 and how we foresee looking into the coming year in 2025. I would like now, if it's okay, to introduce our featured speaker. His name is Noah Ridgway. He is an attorney and partner with Hagenow, Gustoff, and Ridgway. And the lion's share of Noah's practice is devoted to matters involving business and corporate law, estate planning, probate and trust administration, nonprofits, real estate, and then also select litigation matters. Noah grew up in a family of entrepreneurs, actually. So he also is a small business owner himself, and he understands the challenges that clients face and the importance of practical advice and solutions. Noah frequently speaks to professional organizations and members of the public regarding a variety of business and estate planning topics. And before he earned his Juris Doctorate at Drake University Law School, Noah received his Bachelor of Arts degree in Economics and Finance from Bethel University in St. Paul, Minnesota. Noah is a member of the Iowa State Bar Association and the Polk County Bar Association. He's licensed to practice law in every state and federal court in Iowa. And interestingly, Noah is a fifth generation resident of West Des Moines, Iowa here, where he does live presently with his wife and children. And of course, Noah and his family are active members of the community and his church, Valley Church in West Des Moines. So without further ado, I would like to introduce Noah Ridgway. Of course, one disclaimer we always put in before I turn it over to Noah, and as I'm sure he would probably attest to, all of the information today is general in nature and for informational purposes. We ourselves at Harvest Point, we are not attorneys like Noah, but and we do not therefore provide legal advice. So we would encourage you to seek out, of course, your own individual legal advice and just kind of take the ideas and information that you hear from Noah today and apply that to your own situation. We're happy to facilitate an introduction in that regard to Noah or to another attorney, as we have in the past for you, and to continue that conversation. So with that said, Noah, let me turn it over to you, and thank you for your time today and all the wonderful information you are going to share with our clients and guests on the call.
Thank you so much, Tim. Thank you so much, Tim, and folks at Harvest Point. I appreciate the opportunity to talk with you all on an exciting topic. And as we launch into the holiday season, I mean, we're talking about death, dying, taxes. We joked about that earlier. It's a good topic to handle. And the holidays does present some opportunities to meet with family, start to have some of these conversations, maybe revisit documents, look at present circumstances, and see if how things are set up is how you want them to be played out later on. So estate planning as a whole, when you do these introductions with people and you describe what your vocation is, what you do for work, and I say I'm an estate planning attorney, sometimes I get this glazed look and there's confusion as well. Do they manage my investments? And so I've started converting and I say, oh, I'm a wills and trusts and estates attorney. And sometimes that seems to clear things up a little bit. As a whole, though, estate planning covers a lot of different topics. So ultimately, we are looking at the assets that somebody owns and figuring out ways that we can usher them to the next generation, to charity, to beneficiaries, to make sure there's a plan in place to deal with kind of the two triggering events, which are death or incapacity. And we're looking at those events for not only you, but also for your loved ones, your spouse, your children. And so that touches healthcare, it touches tax. If you're a business owner, it'll touch that. If you own, real estate for investments, it touches a lot of different things. And so it's an enjoyable practice area, and it's fulfilling to meet with families and see people. So that's what we're going to talk about today. On the next slide, I've got kind of a summary of why estate planning might be important. And oftentimes when we meet with people, their primary goals are, I've got assets that I've accumulated over my lifetime. How do I get those to the people that I want to receive them, or to the organizations that I care about? How do I make sure the right people are in positions to be making decisions? And also, how can I, if possible, how can I stay away from the court system? How can I make this process smooth? How can I make it cost effective? If there's ways to save on taxes, can I do that too? So there's a list there, and I think a lot of the information on these slides will hopefully be available as a resource. I'll try not to be married to it, and I'll try to get through the presentation in a good amount of time. So even though estate planning is important, and you're hearing it from an estate planning attorney, so I'm biased, very few relative to the grand scheme of adults that should have an estate plan actually go through the process of setting one up. So there's a statistic that's been going around this year that only 32% of Americans have a will, let alone a more comprehensive, uh, more detailed estate plan. And this same survey also revealed that 64% of Americans actually think that estate planning is important. So there's obviously a gap, both in people that understand and know what estate planning is and see its importance, but also a gap between, yeah, I think it's important, and actually taking the time and getting that process completed. So we'll talk, hopefully, in a more practical sense about what documents are involved in a estate plan. If I've already got something set up, what should I be looking for if it's time to review things, and what those different documents do and what they might look like. So here's kind of a list, and we'll go through each of these in more detail on the slides that follow. But if somebody walks in the door into our office and meets with one of our attorneys, the idea is we're looking at all these pieces. Either do you have something in the past that's in effect that we might need to change or at least look at? Do we need to create something new? And if so, these are the common documents that we see. And there's obviously many, many more that will kind of go with it as ancillary items. Or in more complex estate plans, there may be additional trusts and things. But for the most part, this will cover the vast majority of clients. This is a diagram here on this slide, this house, that we use as an illustration to clients that estate planning can, if done correctly, be a lifelong process. So there's definitely people that we've met with, kind of hospital call, for lack of a better term, where nothing's in place. We need to get a will done. We need to get something set up just to make sure that things go as smooth as we can at that point. We've done those types of visits, but it's often a much smoother process if you take care of this ahead of time and if you keep it updated and keep it current. So the first layer of this house is powers of attorney, and oftentimes this will deal with you being incapacitated or your spouse being incapacitated. And there's different categories. We want to look at how do we make sure that your financial matters keep moving forward, make sure tax returns get filed, make sure expenses are getting paid, make sure somebody has legal authority to actually take care of these decisions. And then also, in a similar sense, but on the healthcare side, if you can't indicate what type of care you want or need, who do we have that's appointed that could step in and help and make those decisions? So these are documents that allow for those things to be done. In a perfect world, or in estate planning's perfect world, we'd love to see anybody over the age of 18 have these documents. And so we'll have clients, as you can imagine, there's not a lot of 18, 19, 20-year-olds that are knocking down our door trying to get powers of attorney. But there's clients who have kids that go off to college, and there's concerns that, oh, if they get hurt or if something happens and I need the help, they're still, in reality, my dependent. I'd like to have legal authority to actually step in and be of assistance. So that's kind of the first layer there. And once that's complete, and once people start accumulating assets, they often look at, well, what happens with these things that I've acquired when I'm gone? Another common trigger is you get somebody that gets married, they have a kid, they want to have a clear plan for what happens to my child if I'm gone. Who's going to take over custody? Who's going to be their guardian? I want to make sure that they're taken care of. So that's where we look at this last will and testament, or will. And this is the document that everybody's familiar with. This is what we see in movies and TV shows. And historically, this is how we dealt with distributing assets to people. If you do not have a will, there's a misconception, or there has been in some people that I've met with, that your assets just revert and they go to the state, to the government, and your family loses out on them. That's not true. If you didn't go through the process of forming a will or a trust or creating an estate plan, the state of Iowa and other states, if you're in a different state, they have what are called intestacy laws, which have basically rules on where your assets go. And they're meant to be intuitive, but sometimes they're different than where you actually want your stuff to go. So a will is a great place where you can direct for those assets to go according to plan, whether it's family or friends or charity. You can also appoint who you want to make those decisions after you're gone. So, and that would be an executor or personal representative in Iowa. So we get this question all the time where people come in either in the estate planning phase or after somebody's passed away, and they show me the will and they say, look, I'm going to avoid probate. Everything should be smooth. Like, let's start transferring assets. Let's get this thing done. That's not really the case. So if you have a will, it does not mean that you avoid probate. And we'll get into this in more detail later on. A lot of people also say, I have a trust. And what they're referring to is this term that's at the bottom of the slide, a testamentary trust. That's a type of trust in your will or that document that forms a trust at death. And that type of trust does not avoid probate. There's a different type of trust that we'll talk about later on that does avoid probate. So there's some misconceptions that people sometimes come in with. And probate as a whole, we'll talk about here on the next slide. It's a legal process to wind down somebody's affairs and transfer assets to their beneficiaries or heirs. The process also involves notifying anybody that might be interested. So any family members, any beneficiaries, any creditors, making sure that debts and expenses are paid off to creditors, making sure final taxes get filed, and ultimately that the assets go where they're supposed to go. So it's a court process. It involves a lot of work and it takes quite a bit of time to go through. So probate generally is something that people want to avoid when they come in and they're going through their estate plan process. It can be quite expensive. So there are hard costs involved in probate. I've never seen anybody successfully go through probate without hiring an attorney. And so attorneys can be paid in Iowa up to 2% of the overall value of your estate, which can be a massive amount. There are attorneys, like our firm as an example, we oftentimes don't charge 2%. We probably just stick to an hourly rate. Depends on the size of the estate. And try to make it fair. So you've got attorney's fees, you've got fees that would be paid to your executor, you've got court costs, you've got publication costs, you've got accounting costs. All these costs added together. Surveys like to throw out the number 2 to 3%, but it's all relative. If you have a smaller estate, that percentage may be higher. If you've got a massive estate, percentage is probably lower. But you're probably looking at spending, $10,000 to get this process complete if everything goes, smoothly and according to plan. So that's a criticism of probate. People want to avoid it. It's also a court process, meaning a judge is supervising it. And when a judge is involved, they can start to interfere and make interpretations that are different than what you actually wanted to happen. So the question then becomes, well, let's avoid this probate process. Let's avoid those costs. Let's avoid the delay. How do we do it? And there's many different ways. Ultimately, when someone comes in, we're going to look at every asset they own. And when they're working with an advisor, that's even better because oftentimes it's organized quite well as far as what all is out there and who owns what, if it's a married couple. But we look at each asset, and each asset needs to fall into one of these 5 categories in order to avoid probate. So if it's a gift during a lifetime, that means you actually don't own the asset, so it doesn't need to go through the probate process to be transferred to the beneficiary. If it's a bank account, for example, those have payable on death or transfer on death designations. We can avoid probate that way. If it's a life insurance policy, you can name a beneficiary, and those proceeds will be paid directly to that beneficiary without going through this probate court process. If you're a married couple in Iowa, your deed to your home probably uses language like joint tenancy with rights of survivorship. That's another process where basically survivor takes all, so we can avoid probate. And then for anything else that doesn't fall into those categories, we can create trusts which own and hold those assets. And because they do that, you're left with nothing in your personal name that needs to go through probate. So we in Iowa use trusts a lot more in other states. So if you're listening and you're in a different state, you'll want to check with your local council there. Some states allow you to name a beneficiary of a piece of real estate, and and at death, that asset is transferred directly to that person without needing probate. Iowa does not allow for that. So oftentimes people create trusts, and especially people that own any sort of real estate, they own a business or any other complex assets. A trust reads and looks a lot like a will. It's a document that will direct what happens with your assets while you're alive, what happens when you become incapacitated, and what happens with those assets when you're gone. So the idea is this is your safety valve. Anything that the trust owns can be distributed to whoever your beneficiaries are and completely avoid probate. So when we're doing in-depth estate planning, this is a tool that we use all the time. And if we're looking at the clients, at least at our office, probably 70% or so are folks that are using these revocable living trusts as a rough number. And then the trust itself, because estate planning, what makes it hard is it's a lot of terminology. And attorneys like to use Latin and different terms and things like that. So what actually is a revocable living trust? It's a trust, meaning it's a legal entity. So if you've ever set up an LLC or been involved in any sorts of partnerships or things like that, that's a separate legal entity which has its own rights, which can own assets independently of the owners. So it's a legal entity like that. It has three main parties: a grantor, a trustee, and a beneficiary. So a grantor is going to be the person that forms the trust. They sign the documents, they put their assets into it. That's going to be you. That's going to be you and your spouse if you're married. There's a trustee who's the person who actually is going to manage the trust. Trustee has the ability to decide how assets are invested, whether to buy or sell something, whether to make any sort of distributions. That's the trustee's job. And ultimately, there's also a beneficiary. So grantor, trustee, beneficiary. Beneficiary is who gets the benefit of these assets. Oftentimes, the trust is set up so that you are all three of those things during your lifetime. So you form it, you control it, you benefit from it. And then at different events, such as incapacity or death, those roles will change. You may have your spouse or your kids be beneficiaries. They may be trustees if you're not able to make decisions. So there is a document, a trust agreement, which lays all that out. So that's the trust. The trust is revocable. That's how it gets its full name. So you can change it, you can amend it over your lifetime. So you could change it 5 times a week if you wanted to. You probably don't want to pay an attorney to do that. But it is flexible and it gives you a lot of control, especially if you've got, maybe younger kids or kids that are going through different life stages. You're not sure, do I give things to them, no strings attached, or do I need a little bit more control or protections for them? It allows you to modify and make those decisions later. So the trust works by transferring assets to it during your lifetime. So if you own real estate, for example, you're going to file a deed to transfer the real estate to the trust. And in that sense, it's a living trust, in that you're putting assets into it while you're alive, and it will have assets in it until they're ultimately distributed after you're gone. It's a grantor trust, so there's no income tax consequences on it. So it's very easy to implement, and it doesn't hurt you in any way in that sense. So we do a lot of those trusts, and kind of the next step up from that is there are a lot of tax issues that you can run into. So you see this list on the left here that's got 5 different types of taxes. We call these, tongue-in-cheek, the spheres of attorney malpractice. So if we are not looking at every single one of these tax issues that can come up in the course of setting up somebody's estate plan, any one of them can bite you and can cause really adverse tax consequences to the client. So we are very careful to look at every asset, whether it's qualified or non-qualified. If it's real estate, we're looking at the basis on that. If it's a business interest, to make sure that we're not hurting you with the estate plan in any of these areas. And there are actually things that we can do to improve your situation, to make sure that your spouse gets a stepped up basis, to eliminate or at least mitigate capital gains tax. There's things that we can do to definitely mitigate federal estate tax. So I don't want to get into too much detail on that topic for this this presentation, but just know if you've got a lot of assets, there are a countless number of tools that can be utilized to try and mitigate estate tax, and that's a tax worth avoiding. Generally, it's 40%. So this chart here has a number of those different tools described, and then on the next slide here. If you're listening to all of that and you're like, yeah, I need to probably start this conversation and go through this process, but I don't even know where to begin. I would say every attorney probably handles things a little bit differently. In our office, what our practice has been is we just want to have a first meeting, however you want to do it. If it's a phone call, if it's a video conference, if it's in person, no cost, just to get to know each other. So we talk through your family situation. We talk through your goals, the things that you're concerned about, the things that you don't understand. We'd take a look at all the assets you own, how they're titled, and we'd probably offer a recommendation after that first meeting. So oftentimes after the first meeting, we have a pretty good idea of whether this is somebody that would benefit from a trust, would benefit from a more complex trust, whether they just want a will, whether they just want powers of attorney. And we oftentimes, within a day or so, we'll send them an email and say, hey, here's what we think you would benefit from. Here's what all is included there. And here's kind of what the cost of that looks like. So we do all of that with no obligation. So I think that there are a lot of attorneys in the area, at least in Iowa, that have a similar mindset. So I would not hesitate to reach out to a local attorney to start this process. You can talk with your advisor here at Harvest Point, and they can get you connected with somebody too. So that's often the beginning point. If you decide, yep, I'm going to go ahead and I'm going to get a trust started. There's a lot of data that we collect. The documents tend to be long and very, very much including legalese. And so we're gathering administrative things like names and addresses, phone numbers, emails, dates of birth. So we go through that process. And we kind of have an open door policy. So we do all of our estate planning on a flat fee basis. We found that if we charge clients on an hourly rate, that there would be times where clients would kind of ghost us, and then all of a sudden they would say, all right, let's go and let's meet and let's get this thing signed. And the problem there is we didn't feel comfortable that they were understanding and taking enough time to ask questions and make sure that everything was actually teed up and was set up in a way that would meet all of their goals. So the flat fee basis has been great, where we'll meet with you 10 times if we have to. We'll meet with you twice if you don't need that many meetings. So there may be some kind of intermediate discussions where we answer questions, talk through different things, and make adjustments. So we like to send drafts of the documents to clients ahead of time, ahead of a meeting where we would ask you to sign a bunch of things so that you've got time to review them. If you want to have other people look at them, you can. And oftentimes, like a trust document, for example, could be anywhere from 10 to 50 pages. And so if you're like me and somebody says, hey, read this 50-page document, it's hard to find the time. So we'll oftentimes do a meeting just to review the documents, go through every article, every section, explain why it's there and what it does, and make sure everything's accurate, correct. So legal documents, and especially estate planning documents, they have formalities that need to be observed in order to be effective. So in Iowa, we need witnesses and notaries to sign different documents. And so a lot of times we'll meet in person, we'll sign all the documents, get everything set up. We'll provide recommendations on how to get beneficiary designations set up or changed to make sure they're optimized and current. And we'll kind of talk through with family members if you want to get them up to speed on what you've done and what you've set up, and then also share documents at your request with a financial advisor or whoever else. So that's kind of our process as far as coming in prepared. If you're going to meet with an estate planning attorney, in a general sense, you'd want to have a pretty good idea of your assets. You don't need to know exact values, but be able to tell them, I have a checking account at US Bank. I've got a life insurance policy here. I've got a Charles Schwab brokerage account. I've got a 401k through work, just to be able to categorize the different things, because they'll want to know that, both to make sure that there's not any tax issues, but also to make sure that beneficiary designations are current, because they will trump whatever is in a will or a trust. So just to make sure that everything's working together and that your assets will ultimately go where you want them to go. So next slide here. So I've talked a little bit about this, but if you're calling up an attorney or getting a meeting scheduled, these are some questions that you may want to ask ahead of time, just so you're not surprised. I would always ask, is the consultation free? And we get that question asked to us when people are going through kind of our intake process, for lack of a better term. And it is not an offensive or bothersome question to ask at all. Most attorneys, I think, are offering free consultations, especially in the estate planning world. But I would confirm, just so you don't get hit with a $300 or $400 bill for something that's not going to go anywhere. I would also, maybe in that first meeting, ask about pricing, figure out, is this something that's on an hourly rate? Is it on a flat fee rate? If so, what's included in that flat fee? And if it's hourly, can you provide like an estimate of how much time you think it might cost? And then always, if it's a estate plan that you think is really simple, it could be simple, but it can often be more complex than it seems. But complexity can influence pricing, and especially if somebody has a really, really high net worth estate, there's different trusts that are being drafted to try and shelter things from estate tax. That's just more time intensive, and oftentimes the price is going to be reflected accordingly. So as a kind of an anecdote, people make the assumption that estate planning is something that only needs to be done if you have a lot of assets, if you have a lot of complexity in your plan. And the reality is there's no such thing as a simple estate. As long as you have people involved, as long as you have any sort of money involved, as long as you have grief and emotion, those dynamics do not play well together, and it's always going to result in more complexity than you think. I've had estates where there's millions of dollars of assets that have gone 10 times more smooth than estates where there's much less assets, but there's conflicts and different things, or maybe the planning ahead of time wasn't as good as it could or should have been. So I would say once you get an estate plan set up, or if you've recently gone through the process, or maybe several years ago you got documents prepared, and you're wondering, is it time for me to bite the bullet, or at least have somebody look at it just to make sure things are current? These are some different circumstances that might encourage you to revisit your documents. So obviously there's a big family change. If you've gone through a divorce, if you've just gotten married, or if other people involved in your plan, kids, for example, have gone through a marriage or divorce, or they've gotten involved in a lawsuit, there's ways that we could protect assets for them. Obviously, if somebody passes away, or if you have a child, your first child, and you need to get something put in the plan for them, those are all great opportunities to get in and make sure that everything is current. There's been a lot of estate and retirement planning type changes that I'm sure you've talked with your advisor, and those can have impacts too, where estate planning documents need some updates. We try to account for as many contingencies as we can, but sometimes the law changes and we just need to be nimble and change with it. If you move to a different state, each state has their own laws on property, on probate, on trust administration. So there are some slight differences. They're generally meant to be reciprocal, in that if you created a trust or a will in Iowa and you moved to Ohio, we would be able to use your Iowa document, but there might be some inefficiencies based on how Ohio law interprets things. And if you receive a huge inheritance or something like that, where all of a sudden we didn't have a taxable estate, but now we do, that's another great example where it's good to get something in place so we can make sure we're not losing out on taxes, and we can make sure that more of your assets go to the people and things that you care about. So I think that's what I've got for slides here. I'm going to pass it back over to Colin. I think we're going to go through a quick question and answer session.
Yeah, thanks, Noah, and thanks for taking the time today as well to join us and provide your insight. I know we've already got some questions here that we're ready for you if you got a few more minutes of your time. The first one comes from John from Iowa, and he's wondering, how much should I have saved up to consider getting an estate plan done?
I would say, as far as assets, I don't think there is a number. I think it matters more so what types of assets you have, what are you trying to accomplish? Um, and obviously, if somebody comes in the door and there's not a lot there for assets, that's probably not somebody that needs a trust, but there may be ways to avoid probate without it. As just a general, really, really general rule of thumb, anybody that's going to own real estate in Iowa at the time they pass away, uh, a trust is going to be more cost effective for them. They're going to end up saving money on costs and issues later on down the road. So it's an interesting question. I don't know that there's an exact dollar amount. I would say from like the cost to actually get documents prepared, you're probably looking at anywhere from 600 to, if you're an individual, 600 to $2,000 in costs, and a married couple, it could be more. So that's just kind of a general range.
Yeah, I think that makes a lot of sense. And for those of you who still have questions, feel free to email them into our info@harvestpointwm.com inbox. And if we don't get to every question today, or if you'd rather ask a question offline, feel free to send it in to us afterwards, and we'd be happy to either get Noah's opinion or maybe we can provide some insight for you. The next question that we have is also from Iowa. It's Logan from Iowa, and he wants to know, do I need to notify my beneficiaries about their role in my estate plan?
You don't need to. So there's no legal requirement that you notify them. I would say that the best plans are the ones that are communicated. So there's always an exception. If you've got a family member where you're worried, or a child as an example, you're worried about them quitting their job because they found out they're going to receive millions of dollars from your estate. Yeah, maybe that's not a good idea to tell them and have them be under that impression. Um, I would say if that's not an issue though, communication is key. I got into this industry of the practice of law because when I was in law school, I had three grandparents pass away, and I got to see very different types of planning that was done and communication that was done. And surprises are really difficult to figure out because you're not around to clarify how things should have been done. So if you can head those questions off now and make sure that there's clarity while you're still around to provide it, I think that's a big advantage and a wise thing to do.
Great. Thanks for that, Noah. One question that we just got in from Bob here in Iowa is for Noah again. We have a few homes we own as rentals, and we currently that each are currently in and listed towards the LLC. Would it be smart to leave it in the LLC or immediately move it into a trust? When would be a good time to transfer title from the LLC into the trust?
Yeah, good question. I would leave them in the LLC. So what you can do, the trust is there's kind of an umbrella that you create with the trust. So if you're married, you and your spouse are up here and you form a trust, the trust then just needs to own everything, or it needs to have things directed to it at death. So the trust could own, for example, the ownership interest in your LLC. And by doing that, it would be able to avoid probate. So, and that would be a really easy transfer to do. There wouldn't be really any reporting. It'd be kind of a private document that you just keep in your files. So I would say, as far as timing, whenever you've got the time to get the process started, it'll have no tax consequences on you. So it's not like, let's get it done before end of the year or wait till next year for any reason. It's just a matter of your availability.
Great. Thanks, Noah. Before we head off, I wanted to provide everybody with Noah's contact information just in case they wish to reach out to him. Or if you'd rather us help make the introduction to Noah, feel free to reach out to your advisor, and we'd be more than happy to make an introduction to Noah or one of the other attorneys that we have had experience with in the past. So happy holidays and Merry Christmas from our team at Harvest Point. We're happy to serve you. Just as a couple of reminders, once you close out of the Zoom webinar today, there will be a short survey. If you could please take that so we can continue tailoring these webinars to the topics that you want to hear about, that will be the best way to do so. We consider it a privilege to serve you on a daily basis. We all come to work joyful and energized every day, and that's because we get to work with folks and friends like you. So Merry Christmas from the team at Harvest Point, and Happy New Year as well. Thanks all.